I'm Bill Price with growthlaw.com. This video explains immigration issues for international investors in U.S. real estate. International investors generally have two major types of objectives when they think about U.S. immigration. One set of investors may not need a U.S. green card or have any interest in U.S. citizenship. For these investors, there are different business visa options available. The business visas you may want to think about have some initial restrictions, however. The Trump administration has recently imposed, and the U.S. Supreme Court looks to uphold, some limits on countries where there are active war operations or some Muslim populations that may provide a problem for review before any type of immigration application goes through. Your travel advisors in your home country and your travel agency can usually assist you on these. When it comes to business visitors, and these are the major business categories, you have initially an idea of a short-term visit. Most business visas are B visas if you're talking about entrepreneurs or treaty traders, but these visas can go for as much as a 6-month visit to the United States, which is plenty of time for business meetings, plenty of time for general supervision. In addition, there may be specific arrangements from country to country that allow the 6-month term to be extended. In China, for instance, you can get up to 10 years of business visas, usually applying approximately every 6 months, but for a total 10-year term, which is more than enough time to deal with most business ventures. If you have someone who is to work in the United States but does not need an immigrant visa, there are a couple of different categories. First would be for executives or workers of international firms. This is what's called the L visa. The L1 is for the executive themselves. Obviously, you prove that you've got a return ticket available, but you also prove employment in an international organization. The L1 visa holder, like the B visa holder, can bring in family members with them. The difference is B visa holders are for general business purposes. L holders are employees, and there is a second L category for employees' families. That is the L2 visa. One other employer category may be worth looking at. There is a category called the E1C. For other persons, that is a genius grant type visa for persons of extraordinary qualification. The E1C, however, has much simpler requirements. You simply have to be the business owner and be able to prove that you are visiting the United States for the purposes of your business. There's a further and fairly famous category for business employees who want to have an extended stay in the United States. This is what is called the H-1B. For this category of visa, the employer makes the application. They need to prove that U.S. citizens are not available for the special skill for which the visa holding person is to be brought into the United States. There is a time period under the H-1B which the visa holder can operate in the United States. They have to stay employed by that original employer unless they can apply and get another H-1B granted to a different employer and then shift status from one visa to another. And of course, they do not get a U.S. green card at the end. They are expected to go back to their country of residence. One further note on the H-1B. This category of visa has got a quota, and H-1Bs run out most years, so they are not available for all employees. The L1s, by contrast, do not have a quota. The B visas do not have a quota. I'm now going to shift to immigrant visas, the various ways that people from other countries can come into the United States and seek a green card because of a business connection. The first step towards a green card is often a non-immigrant type of visa. At the University of Illinois, in the state where I live and practice law, there are more than 8,000 citizens of China, and there are several thousand citizens of other countries. Student visas allow work-study, but not other employment in the United States, and are not themselves business visas, but are also often reasons why people are in the United States and want to establish something that they can go to after they are students here, so they do not have to leave and return to their country of origin. An application while inside the United States for change of status is allowed to any other visa status, and the various types of non-immigrant visas or immigrant visas are all possibilities. Within the immigrant visa categories, the most famous is what is called the EB-5 visa. This is one where if a person or organization invests more than $1 million in a U.S. project, and real estate projects often are a type of project that seeks EB-5 investment at international locations, then the EB-5 can be granted if the $1 million is kept in the organization for at least 2 years, and if at least 10 U.S. jobs are created. There are 10,000 available EB-5 visas in any given year. Those EB-5 visas start the process of USCIS consideration of a complete visa application package. It may take another 18 months for the agency to finish making a decision. The 10,000 slots run out quickly. There is a lottery. The slots usually disappear over about 3 days of applications in March, April, or May of any given year. For most countries, there is more than just the EB-5 available. For these, you have what is called the E2 visa. Now, which countries have this? You can look on the USCIS website and see if there is a tax treaty between the country of origin and the United States of America. China, for instance, does not have a tax treaty. Brazil does not have a tax treaty. Mexico, however, does have a tax treaty. So does the Philippines. So do most other countries in the world. And if you look at the major countries and major economies and find there is a tax treaty, the E2 visa is an option if you are investing in a U.S. business. What is required is proof of a viable business, and this your U.S. real estate partner can help work with you on. You do not have any specific job creation requirements, but the business plan does need to show that the immigrating entrepreneur and their family are going to have a viable business and not likely become persons who will go on welfare or Social Security. As little as $10,000 has been allowed, but the average investment that is approved by USCIS is usually closer to $300,000 or $400,000 for a new business startup, such as a franchise or a real estate development, because that cost comes in for land development, for hiring people here, and for the other costs of business establishment and operation. The deal team you may want to use for immigrant and non-immigrant visas is fairly simple. You need a lawyer who can help prepare the application paperwork for USCIS. For regular business visitor visas and travel visas, a travel agency can assist with the process of working through the local U.S. Embassy to apply for a visa. And if there's a student employment or H-1B or other sponsoring organization, there's often a department that is familiar with that paperwork and can assist the individual applicant to work with the employer or work with the university to get admission to the United States. Thank you very much for your time. I'm Bill Price of growthlaw.com.